Hi everyone. This week's video is discussing the right to be accompanied at a disciplinary hearing, and specifically an employer's right to make a determination as to the reasonableness of any representative that wants to attend a hearing. Now, the right is set out in the Employment Relations Act 1999, sections 10 to 15, for anyone who is interested in a good read. This confirms that employers have the right to be accompanied by a trade union representative or fellow worker when attending a disciplinary hearing. The Act also creates some right of redress for an employee whose rights are restricted. So if their employer, for example, doesn't allow them to bring a representative to the hearing. Now, importantly, investigation meetings and consultation meetings are not included. Essentially, where a meeting is not going to result in a disciplinary sanction, there is no absolute right for an employee to be represented. Now, that might be superseded by provisions in the contract or a disciplinary policy which does allow for representation, but the basic position at law is no right to bring anybody with you unless and until we reach a meeting where we're considering issuing a sanction or obviously dismissal. Now, the legislation is quite light on the reasonableness of a request. It states the employee must reasonably request to be accompanied at the hearing. The legislation does not address the question of when a request would be considered reasonable or not. The companion needs to be somebody employed by the union of which they're an official, any other official of a trade union who has reasonable experience of acting as a companion, or another one of the employer's workers. Very importantly, an employer cannot deny the worker their choice of companion if the companion falls within one of those categories. That was demonstrated in the case of Toll, the first case that's really given us some clarity around employers' rights to refuse somebody attending with an employee. In this case, employers had raised grievances with their employer, made it clear who they wanted to be accompanied by. This was an official of Unite, the union. The employer refused the request, and instead the individuals were accompanied by a fellow worker and then by a different union official on appeal. The employees brought claims for breach of Section 10 of the Employee Relations Act, i.e. that the employer had unfairly restricted their rights to bring their chosen representative. Now, GBLs had not been in breach, and they firstly did decide that the reasonableness of a request did not extend to the choice of companion. However, the employees did choose somebody else to go with them. Now, that was overturned on appeal, and the most important principle to take from this is not necessarily whether or not choosing a substitute representative avoids liability, but can the employer restrict an employee's chosen representative? The case is clear. An employer cannot refuse the request on the grounds that a companion's presence might prejudice the disciplinary hearing. So in reality, we often have questions from employers about representation where, for example, they don't want a colleague in for reasons of confidentiality or because they may in some way prejudice the hearing. Sometimes that employee might just be have a reputation for inappropriate behaviour or aggressive behaviour themselves. Well, in those circumstances, they do need to be permitted to come to the hearing, but they can be removed if they do start to behave unreasonably. The ACAS Code on Discipline and Grievance Practices has been updated as a result of the Toll case. So where an employee reasonably requests to be accompanied, the employer does not have the right to turn down the chosen companion if it falls into one of the three categories that we discussed earlier. The ACAS Code does also ask employees to bear in mind the practicalities of an arrangement by choosing a companion who is suitable, willing and available on site, but still the employer is very much restricted in terms of allowing a companion once the employee has decided who that should be. Well, that's very helpful. If you need any further assistance on conducting discipline and grievance hearings or any other employment matter generally, please do get in touch, chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.